The PAR Education Series. Thank you for taking time from your busy lives to join us today. This series has been planned by the Education Committee of PAR and will continue into 2021. So keep an eye on your email and your newsletters for future events. We are very grateful to the PAR Education Foundation, which is a generous co-sponsor of these virtual events. If you have questions today, we're asking you to put those questions into the chat feature, which can be found by hovering your mouse over the lower toolbar on the Zoom page. Also, please remain muted throughout the presentation. Today, we're going to hear about topics from the Legal Hotline. We're very fortunate to have with us today PAR Director of Law and Policy, Hank Lerner. In his role, he oversees the standard forms and professional standards programs and works on all sorts of various legal, regulatory, and compliance issues for the association. He's a frequent speaker on legal, ethical, and risk reduction issues around the state and beyond, and has served on many NAR committees and in other roles. He earned his bachelor's degree from the University of Pittsburgh and his law degree from William and Mary Law School. He's been admitted to the bar since 1994 and has been with PAR in a variety of positions since 2000. Please welcome Hank Lerner. Thank you, Hank.
Thank you, Pam. Happy to be here. And my fervent hope for today is that since my 20-year anniversary comes up in about 2.5 weeks, is that I don't say anything on this call that causes me to, not make my 20-year anniversary. So hopefully we'll be able to get out of this alive. I am here today, to talk to you about Best of the Hotline. So hopefully everybody on your screen now sees a slide that says Bucks County Association of Realtors. Looking for a couple of nods there. All right, awesome. This presentation is something, as you'll see here in a couple of minutes, that actually flexes a little bit from association to association, because we have the ability, as we're going through here, to actually look at this and identify trends from each local association that we can do here. So this is going to be a program created just for Bucks County. It's not the same one I did last week or the one I did next week. Brief agenda. We're going to do a little bit of background here, talking about the hotline and some tips and tricks about how to use the hotline better, some statistics from the local association. Then we're going to hit the issues and we're going to talk about a Q&A. As was noted, if you have any questions, please put them in the chat. I will be able to come back and take a peek at the chat periodically, but go ahead and put your questions there. I will just let you know now, if you have any questions about advertising, don't ask them, because we will be doing an advertising specific program for Bucks County in a little bit in December, I believe. So we'll have time to come back to those specifically. Excuse me, and we won't be talking about those today. So with that, we're going to talk a little bit about using the hotline. You may be aware that as of 2019, middle of 2019, we brought this in-house. It had been run by our outside attorneys for about 20 years. We brought it in with 4 staff attorneys in the middle of last year. One of the things that we're able to do with that is extend the hours. So now that we're not paying by the hour, but we have staff attorneys working on it, we sort of opened up the hotline for the middle hours of the day. Instead of a 9 to 11 and 1 to 3, it's now open 9 to 3 to take messages. If you've never used the hotline before, you call the hotline. We ask you for your name, your telephone number, and we ask you to leave a brief message about what you're calling about. That is really, really super helpful for a couple of reasons. Number one, if it's something we need to do a little bit of research on or sort of pass around within the department to figure out what's going on, it's really great to know that in advance before we call you back. Number two, I will just tell you flat out, if you don't leave a message, you go to the bottom of the queue. So the people who follow the directions when they leave a message, we try to call back in order as best we can. As you see here, we guarantee to get back to you in some way within 1 business day. We try our best to get back on the same day. Yesterday, I had about 12 calls that all seemed to come in between about 2 and 3 o'clock. I believe we got back to 11 of them by the end of the day. 1 or 2 were emails because it was something where I could just send a link that had the answer. The rest we called back. Only 1 slipped through to this morning, and they got called first thing today. But if you don't leave the message, you don't tell us what you're calling about, you are going to go down to the bottom of the list, and we're going to call everybody else first. we're going to talk a little bit about what the legal hotline is not, as a way of sort of backing into ways that you can have a better experience when you use the hotline. We are not mind readers and we are not magicians. What does that mean? It means I got to use the button the right way here. We don't know things unless you tell them to us. So if you call in and you say, I've got a question about this thing, we'll answer the question about this thing. If that thing was really your super secret way of leading into your real question, just knock it off and ask the real question. We don't have time to kind of go through all that. This is not an academic exercise. So if you have a question, just ask the question outright. That's helpful. And give us the details. For example, one of the earliest calls we took when we brought this in-house was an agent who went through this really, really complicated scenario where a transaction fell apart at closing. The client he was representing was like, I don't know, holed up in the woods somewhere with no cell phone service. There was a question about how to extend the deal because technically he wasn't able to sign anything to extend it. We went through a whole series of what ifs. And after nearly a half an hour, which I'll admit was way too long for the call to begin with, after a half an hour, he said, by the way, I should probably tell you my broker was really upset that this fell apart and he fired me. Does that change anything? To which we said, yes, the entire half an hour we just spent on the phone was completely worthless because you do not have an active real estate license. You cannot practice real estate. So none of the things we told you or suggested that you should do, you can do because you don't actually have the ability to practice real estate right now. I had another one of those just last week. Somebody who said, I've got an issue with a termination of an agreement of sale that they did after the inspections, and they used the word inspections, I don't know, 10 times. So we spent, I looked at the clock, 18 minutes talking about that one. And as I closed, she said, oh, and I should say they were really trying to terminate based on something that they said wasn't in the disclosure form. So I actually literally said at that point, would have been nice to know that 17 minutes ago, right? So this sort of ties those two together. You asked a question about inspections. That was apparently not the question you were actually asking. So please just be straight up at the beginning of the call and let us know. One of the things you're going to hear us say a lot is the way you framed the question, the answer is blank. That's why we do that, because we can only answer what you asked. Next thing, we're not magicians. We cannot make you competent in 20 minutes. We get an unfortunate number of calls from people that start out with something like, I've never done this kind of transaction before. The client is coming to my office in about an hour, and I'm hoping you can help me understand the forms. That's not practice competency. That is not something you should be doing to begin with. And we cannot help you become competent in commercial real estate in the 10 or 15 minutes we're going to be able to spend on the call with you. We can help explain what the form is. We can help get you up to speed on a couple of things here or there, but we are not here because we're supposed to sort of be able to train you to get you competent in a new area of practice in a very quick period of time. That training is what you take education courses for. It's what your broker can help with. The hotline is not here to sort of do that kind of in-depth training because we simply don't have the time or the bandwidth to do it. We are not your lawyer. You're likely to hear that on probably 50% of the calls in some way or another. We can provide you general information. We cannot tell you what to do in this specific transaction. So we can say, you might want to do this or you might want to do that. You should talk to your broker or the client and see how they want to progress. We're not going to write you the letter. We can't give you that detailed advice. We cannot and will not interpret agent drafted language. We're going to talk about that a little bit more specifically here in a little bit when we get to some of the topics. So this is not an example I would use later on, but a while back I had somebody who called and said, need to know if the sewage replacement plan that we're working on is really a good one, and if we're going to be able to complete it by closing. Like, I don't know. What you're going to read me your sewage plan and ask the legal hotline to tell you if it's something that the septic company is going to be able to put into place? Like, we that's not even within the scope of what we do. And he wanted to know if the amount of money that they were holding in escrow was going to be sufficient to pay for it. Again, we don't know that. That's the sort of stuff that you're going to have to figure out individually for each transaction. What we could tell you, and what we did talk about with this person, was how it works when you hold money in escrow for repairs, and we could point you to the PAR escrow form, but we couldn't actually write the escrow agreement, tell them how much they should hold, how long they should hold it for, and things like that. And personal transactions. This is starting to become the bane of my existence. Tying these two slides together, we had a caller fairly recently calling about a landlord-tenant situation. As was framed initially, said the owner of the property has yada, 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 and they want to know something, something, something. I said, oh, okay. So what's your role in the transaction? Well, I represented the person when they bought the property. Okay. Are you doing property management? No, they just came to me for some advice and information. I said, okay, that helps because, we need to know kind of what your role is before we talk about it more. And then there was a long pause, and the person on the other end said, yeah, actually, I own the property. I'm the owner. So this member, for starters, flat out lied to me, right? Because we asked, what is your role in the transaction? And they misrepresented their role in the transaction. So that wasn't great to start with. Um, the fact of the matter is, if you're calling about your own individual personal transaction, if it is a transaction that is in the market, we will provide some assistance because you are still somebody who is engaging with a consumer for the purchase or rental of real estate, and that is still something that is within the scope of the PAR Legal Hotline. But honestly, we're going to handle that a little bit differently than a true arm's length transaction where you're the agent. We are not your lawyer. We are not here to help you write your lease for your own rental properties. We can talk a little bit about leases, but we cannot provide you specifically with legal advice. So for example, if I sound a little testy, I apologize, but we've been getting a lot of these recently. Please do not call us and say, my kid is in college and I'd like you to look at their lease and let me know if it's a good lease or not. That is purely your personal transaction. That is not something that the legal hotline can take care of. We do have some members who would say something like, but we're paying you for this service. And we do remind those members, if they want to go there, that while they are paying for a legal hotline service, but for example, the other people in their local association probably don't believe that their dues are going to us subsidizing reviewing college leases. So please try to keep it to a market-based transaction. And if it is your personal transaction, let us know, and we can provide the appropriate information with that. With that background. Last thing, we are not your broker. What does that mean? You need to talk to your broker first. Is there anybody on the call who thinks that that is too subtle of a way of expressing it? The best calls we get at the hotline are weird little detail things where the person says, I've spoken to my broker about this transaction and we just have a couple of things that we need to clarify. The worst are when they call in and they start asking us questions about things that are clearly brokerage policy, because these are things that we can't answer at all other than to say, it could be any number of things, talk to your broker, or things that involve like, my client said they're going to sue me, what should I do about it? Step one is always you need to talk to your broker. I've got the asterisk there because broker could mean manager as well. So please, for heaven's sake, talk to your broker about these things. It is their job to help you through these things. Not everybody knows everything. That's why we have the hotline, so you can send these questions on. The other reason for it, frankly, is that if the brokerage is working reasonably efficiently, it should be faster to talk to your broker or manager than to call the hotline, because while we do try to get back to you within a day or two, sometimes we end up having to play phone tag for 3 or 4 days, or we'll send you an email that you don't see right away, whereas the broker should be more available. And we do get at least a couple times a week somebody who calls, leaves a message, and then thinks to talk to their broker, solves the problem, and then doesn't answer our phone calls. So we spend 3 or 4 or 5 days calling them back, only to finally connect and have them say, oh yeah, I didn't need the help, I took care of it. So please talk to the broker first, and if you do solve it yourself, it would help to call back to the hotline. Just leave us a follow-up message that says, please take us out of the queue because we've taken care of the problem. All right, so that's the background information. Pardon me for just a second. Now we're going to jump into some of the data. So one of the things that we promised when we brought this in for PAR to do this in-house was that we would be able to do a much better job of collecting data from the hotline. So our outside counsel was collecting some basic information, but it was really basic information based on some of the limitations of the technology. We've got a snazzy new customer relationship management or member relationship management system that lets us track a lot more data about the hotline calls and keep track of things. So I'm just going to show you a little bit of what we're collecting so you have a general idea of some of what's going on in the background. This slide here shows the ticket volume by association. Don't worry about trying to get into this super teeny tiny text there. I'll explain what's going on. You can see some other association in your general area down here has the most calls. This is a 12-month average, so it's over the last 365 days of hotline service. But look at this, Bucks County is number 2. So just in terms of volume per association, you can kind of look here. There's no surprise. The ones that have the most calls tend to be the largest. Although we do have, for example, Greater Harrisburg Association is well ahead of the Realtors Association of Metropolitan Pittsburgh, which is much larger. So, there are some anomalies where associations maybe are more or less likely to refer people to the hotline. Maybe there are brokers. I don't know this to be the case as far as a rationale, but I know Ramp has a number of very large brokerages that control a large portion of the market that have in-house attorneys. So it may simply be that many of the agents out there go to their in-house legal counsel rather than calling the hotline. I don't know exactly why, but it's interesting for us to sort of see that, see those numbers and how they flex over time in terms of where the calls are coming from. This is a fun one. This is the ticket volume by week. So this goes back to last October. When we brought the hotline in, we were expecting somewhere around 25, 30 calls a week. So call that around maybe 150. So right about here was what we were sort of expecting maybe as an average. And you can see through the end of the year, last quarter of the year tends to be a little bit slower. We got a couple of holiday weeks in here, but those numbers stayed pretty steady with what we were expecting. Now you may have heard there's a little pandemic thing that's been sweeping the nation over the past 6 or 8 months. So you can see that in our call volume. Here it is at beginning of February. We get into March. Whoa, we're way up here into like 275. This month right here, this week right here, we're averaging 175 a week. Our top week right here, this was the week real estate reopened. We had 355 tickets that week. That comes out to 70 per day. So we somewhere in the at least doubled or tripled our normal volume during the course of that particular week. That's with all of the other resources that we had, everything else that PAR was doing at that point. And now you can see we've kind of settled back down into something that's way higher than the average, but it's at least a little bit steadier. So this is really helpful for us in terms of our staffing, figuring out what we should be expecting over time, and making sure that we have just the number of hours available from our attorneys to make sure that you see what's going on. And it really does help show frankly, the amount of work that we're doing. So identifying the number of tickets that are coming in, you can see that it is responsive. People do seem to be responding to the hotline based on what you might expect based on how the market is doing. Among other things, we track the what we call the topics or the subcategories that come in. We don't have enough information here that any of you can do math based on what you're seeing on the screens because it's all partial based on just a top 10 list. But I can tell you that what we do is we track tickets, not calls. So if you were to call in with 2 different questions about 2 different topics, we might create 2 different tickets. If you were to send an email directly to one of the attorneys instead of going through the hotline like we prefer, we might actually create the ticket and put it in the system anyway to reflect the fact that we had the contact. So the fact that we had 1,551 tickets that mentioned coronavirus doesn't mean they were only coronavirus or that they didn't cover, other topics, but that's just how many times we've categorized that item, on a ticket. So number 1, again, as you might guess, coronavirus. Throwing that one out. Number 2 is landlord, tenant, and property management. I was very surprised to see this, but it's held steady since the very beginning of our data collection last year. My guess is that it's a combination of 2 things. Number 1, many real estate brokers and agents own their own rental properties. So again, this is the source of many of the people calling about their own personal transactions, tends to be leasing transactions. The other one is, as you hopefully recall in your last cycle, landlord and tenant property management, that was one of the mandatory topics. So we had any number of people who would call with, so I took a class last week and it turns out I may have been doing it wrong and now I've got some questions for the hotline. So it was actually really good, and it worked very well in tandem with that mandatory topic, because there were at least some number of students who took the classes, realized that there were things that they needed more information on, and then contacted the hotline to get that information. So that has been number two. I would guess that that will probably trend downward over the next couple of years then as people kind of get themselves settled. You notice that fair housing is nowhere on the list, given that that is the topic for this upcoming cycle. I might expect that that will sort of move its way up there. So we should prepare for that, get our resources together, and make sure that we know that we are likely to be answering those questions. You can see then inspections, seller disclosure, advertising. Did I mention we're doing an advertising session for Bucks County in a few weeks? Licensing issues, agency, breach of contract, fees, and the return of escrowed funds. That's the top 10. But wait, there's more, because not only can we see the top 10 topics from the state, but we can see the top 10 topics from your local association. This is about the fourth or fifth. Whoop. This is the fourth or fifth that I've done recently. And I'm fascinated, frankly, every time I pull this slide, because it really, associations are very, very different in the issues that they're having pop up in their local area. So what I do is I'll just put the numbers of how this compares to the state average. So you guys are actually pretty close. Your numbers 1 and 2 are the same. Other here pops up as number 3. Other obviously is stuff that we just can't categorize for one reason or another. But then inspections, disclosure, agency. So, you're at 1, 2, 3, 4, 5. You're at number 6 here. Your number 6 is the same as number 7 statewide. So you're pretty consistent actually with what's going on in the rest of the state in terms of the forms, the topics, which will help then generate what we're talking about. Same with the forms, no surprise, agreement of sale is number 1, seller disclosure, listing contract, and the lease. At the local level, similar as well, almost spot on, 1, 2, 3, 4, 5, 6, 7, only down here do you guys come off the average. So you might think that you're above average in Bucks County, but you're not. Apparently you guys are just average with what everybody else is doing.
Hank, we have a couple questions, if that's okay, relating to what you were just talking about with COVID. Do you want to wait till the end?
Yeah, so I'm going to be hitting these when we get actually to our very next topic.
Okay, great, thanks.
Yep. Which is hot topics. Look at this. So the disclaimer here that says I'm probably not talking about you is to say that we will share calls and stories. These are not picked with a message. It is not intended to say, haha, I know you called about this and I want to shame you in front of your colleagues. It is much more likely, in fact, that we're just simply talking about a topic that is something that you also have questions about. So please don't anybody think that I'm pointing at you specifically. Coronavirus is number 1 topic. That right there, parealtors.org/coronavirus, has been and continues to be the main place you can get information from PAR. So we're going to cover a lot of these topics at a pretty high level right now, because I do have 3 or 4 that I want to cover. So the question there was about, the questions that popped up were about open houses. Generally speaking, what I'm going to tell you is PAR is still recommending that you use our best practices. On the coronavirus page, there is a document cleverly called best practices. And it talks about things like limiting, how long people are in the house, limiting the number of people, limitations that you may want to put on open houses, doing the health screenings in advance, things like that. That document has not changed. It was in place prior to the governor's order, where he actually said we could open and gave specific rules. It stayed the same for the most part, with a tweak here or there once we had the whole yellow-green thing going on, and it is still in place now from us, because best practices are still best practices regardless of what the actual state mandates are. We have been getting a ton of questions about open houses. So on the one hand, I'm gratified that so many people recognized, read, and remember the guidelines from, say, May 19th that said that you cannot do open houses, and that said that you can only have 3 people in a property. Those rules, however, are only for counties that were in the yellow and red phases. They do not apply now. What applies now is don't be stupid. So the rules now do not say that you can only have X number of people on the property. They say that if you have people on the property, they need to wear masks and be socially distant and not be, trampling on each other, yada, yada, yada. Um, they don't say that open houses are banned, but they say that if you hold an open house, you need to make sure people wear masks, et cetera, right? So right now there is nothing specific from the state that talks about how many people can be in any one place at any one time, other than making sure that you are using common sense and keeping them apart from each other and protected as best you can. That we published at least 2 different articles on PAR just listed that reference specifically the open house thing, pointing out that they're allowed, and just sort of laying out some of the practical issues that you would want to consider if you schedule one. And we do also have a very specific FAQ on the website. Again, it talks about in the yellow phase, you couldn't do them, but in the green phase, you can. Everybody is in the green phase, so just read that part of the question and move on. I do need to pause here. This is a pet peeve for me personally. It is a peeve that you can see from many members in the marketplace. Wear your frickin' masks. When you go into somebody's house, when you're a buyer's agent, you're taking buyers there, you're taking inspectors, whatever. There is a universal face covering order in Pennsylvania that says that if you are working, you need to wear face masks. If you are in a place where members of the public are, you need to wear face masks. When you are taking strangers into a property owner's house, you have to wear masks. How do we know people are not wearing masks? Well, those of you who pay attention to the changes in our buyer agency and listing contracts may recall that in the past couple of years, we've added language in there, alerting buyers and identifying for sellers that things like video cameras might be on when you go into a property. People are using video cameras more and more. So when you walk up to the property, it's got a Ring doorbell, and you take your mask off before you go inside. The owner of the property sees you take your mask off before you go inside. When you walk in, if they have a camera set up for home security, or frankly, because they're upset that people haven't been wearing masks in their house, so they set up a camera, they are seeing people without cameras. I'm sorry, without masks. Just this weekend, we had somebody who posted a screenshot of one of those cameras on the PAR group. They probably shouldn't have posted the picture. Not that it was illegal, but they just probably shouldn't have done it out of just a general sense of trying to kind of keep things on the straight and narrow here. But they were working with sellers who were really mad, and they wanted to know what to do about it. So just wear the mask. This is not personal liberties. This is not freedom of anything. You are a visitor in someone else's house. The rules are wear a mask. Common sense and respect for the property says wear a mask, wear the mask. If anybody wants to file a complaint about that, you can actually go through the Department of Health website. They have a form there, because technically this is also a violation of not just the masking rule, but also their work rules. So it could be filed through the Department of Health. It can be filed with the Department of State through the State Real Estate Commission. And I can tell you that people have filed them. I can tell you that the Bureau is investigating complaints that are based on non-compliance with COVID rules. So there are brokers and agents out there who are potentially going to be sanctioned for not following the COVID rules by the Real Estate Commission. And it's an open question as to whether this may also potentially be a violation of the Code of Ethics as well. That's probably not the place to start for various reasons, and we're not going to cover it any more in depth here. But suffice it to say that there are places that you can file those complaints. Although, frankly, the first thing to do is have your broker call their broker, and essentially, have somebody read somebody the Riot Act, because this shouldn't have to get to a complaint. It is something that should be fixable before you get to that point. So I'm going to pop up here just to look at the chat. I think that took care of the couple that I had seen on that particular issue.
Yeah, they're right. Yeah, you're correct.
Okay. And I do see another one that says if sellers are home, they should also be wearing masks. Yes. If there are people who are generally near each other, they ought to all be wearing masks. The other point that I have here under don't be stupid is be honest. We are getting, again, sort of a disturbing number of people who are starting to think, well, maybe I don't have to tell the other side exactly what's happening with my client. So we've had people who have said, well, the seller's sick, but they would prefer not to tell the buyers because they're afraid if they tell the buyers, it might affect their willingness to buy the property. It is true, it might affect their willingness to buy the property, but it's far better to tell the buyers now, say a month away from settlement, one of us was diagnosed and here's what's happening. Because if somebody does actually stay sick, have lingering symptoms, and maybe you get down near the closing date and the seller says, oh no, I can't move out because I'm sick. Or an inspector wants to come through, or a contractor wants to come through, and suddenly there's all these random excuses about why no one's allowed in the house. Just be honest. Let everybody know what the situation is and work it out, because it's generally going to be better to do that than it will be to wait until the last minute and possibly have something rear its head. Same thing on the buyer side. If you have a buyer who is a first responder, who's a nurse, somebody who's traveled recently, there's a reason that the health screening asks these questions about whether you're exposed, whether you may have been exposed, whether you've traveled. If the seller does not want somebody who is regularly near COVID patients in their house, that is their choice. So you need to tell them that. That's why we have the health screening questions. In many cases, what we're hearing is that the sellers are in fact willing to let these buyers into the house, let them do showings, walkthroughs, et cetera. But they need to know in advance what the situation is so that they're aware and they make an intelligent, informed decision. If you were to hold back that information and someone were to get sick, it would be a very bad outcome. So just do the right thing, follow the best practices, fill out the forms, and generally speaking, everything will be fine. Hide stuff, it's going to be a bad situation. All right, am I depressing anybody yet? Because that's really what I'm going for at this point. No, there's only like 8 people with their cameras on, so usually I see more people sort of banging their heads against the wall by this point. Next point on coronavirus. I call this contract magic. We have the COVID form, so the very first one we came up with, where if the buyer and the seller agree, so it has to be an addendum that both parties agree to that is attached to the agreement of sale. If that is attached, and if it is impossible to actually complete a portion of the transaction in a timely manner, one party or the other has the ability to extend out the dates of the contract by as long as 30 days, whatever's written in the document. This is not a get out of jail free card, right? This is not, oh, I forgot to give the lender my last pay stubs. They're not going to be able to get financing ready for the closing date. I'm just going to use the coronavirus extension and we're going to extend it out by 30 days. That is not impossibility based on COVID. It might have been impossibility, 4 months ago when employers were unreachable and were not actually available to answer questions from lenders to validate employment, for example. It is not impossibility now. It was just an oversight on behalf of the buyer. We actually had a call very recently from somebody who called up essentially because they had a mix-up in their various addenda. So there were some dates that were the closing date was this. But they ended up signing a sale and settlement of other property addendum that said you have to have your property sold by, and that date was after the proposed closing date. So basically it was carelessness between the two agents and the parties in how they set up the contract. They were not going to be able to make closing because of this. And suddenly the buyer's agent had the bright idea to invoke the coronavirus addendum. Well, if you're invoking it because there was a mix-up in the contract dates, again, that doesn't work. That's not what this is for. However, in talking it through with this agent, she said that part of the issue was that the buyer's current transaction was substantially held up in her telling of it, based on some COVID-related thing that caused the lender in that transaction to not be able to approve financing. So if that is the case, and if there is something legitimately, coronavirus related that caused the other transaction to be held up, maybe it can be used. But really, right now, the timing of that form or the use of that form with the timing is very, very rare that anybody's going to be able to say right now that this is truly something that was made impossible by coronavirus, as opposed to, yeah, it was a little hard and we had a bit of a delay here. The one that comes up over and over again that we've seen a bunch is it's usually on the seller side, and it's the seller saying something like, my replacement property is not available, therefore I cannot move out because of coronavirus. I can tell you that in almost every circumstance, that would not be considered impossibility. Forget about the word coronavirus, right? Because the excuse is usually, well, my parents don't want me staying in their basement because I've got a bunch of kids and they're afraid that we're going to get them sick. That's not impossibility. You could go to a hotel. You could rent a townhouse. The fact that you don't want to is frankly no different than if this situation had popped up a year ago and the parents of the seller said, no, we don't want you moving into the basement, right? It's not impossibility. It's a preference that they don't have to be inconvenienced. They would rather that the buyer be inconvenienced. And we've had usually pretty good luck when we explain that to the agents, to say, look, if it's something that is really inconveniencing, remember that you trying to force the buyer into doing it is causing them the same problem. You just have to work it out. But just waving the word coronavirus around and saying I can do whatever I want is not how this works. So that brings to a close my pre-prepared topics on coronavirus. I saw it looked like one more question popped up. Finding many co-op agents don't want to deal with it because people use it as an excuse. Yep, ding, ding, ding. If I had a bell, I'd ring it. We are finding most people are not using it at this point, or it's simply not being accepted by the other side of the transaction for exactly that reason. And honestly, I'm not your broker. I cannot provide you specific transactional advice. If it were me, I probably wouldn't be accepting it at this point, because I'm not sure that it's really relevant for the most part. But we have it because parties may find it to be something that is necessary or helpful in certain transactions. So it becomes really just another negotiating issue, just like any other form. All right, I'm going to close that one down. And we're going to move on to landlord tenant. So you remember how I just said a minute ago that there's no magic, coronavirus magic, for sales. There is a little bit of coronavirus magic for landlord tenant, and it's in the moratorium that is out there, or the moratoria, I believe is the technical plural. My 10th grader is taking Latin too, so she helps me out with these words when I get confused. So there is a federal eviction moratorium, also covers foreclosure through the FHA. So that is dependent on how a property is financed. There's the CDC eviction moratorium that is for non-payment of rent, and it covers a number of different scenarios, or there's a number of loopholes and restrictions there. So for example, the protection depends in part on how much money you make, whether and how you're attempting to pay the rent now, things like that. And I'll be just perfectly honest with you. Well, I don't have it on this slide. You guys may have run into the fact that the city of Philadelphia has its own citywide moratorium. There was a state moratorium that is now out of play, that expired and has not been renewed. Honestly, we are not answering any specific questions. If anyone calls and says, let me explain to you my landlord-tenant situation, and you tell me if this is somebody that could be evicted, we're simply not answering. There are so many moving parts, different moratoriums that are out there, different criteria that are super transactional specific, depending on the exact circumstance. By way of example, in order to qualify under the CDC eviction rules, the tenant has to file an affidavit with the court that says, I meet the criteria. In some counties, the county says you have to fill out this specific form. In others, they just say you have to fill out a form that meets the criteria. We don't know what every single county in the state requires, so we're not going to be able to tell you exactly how to do it. More to the point, there are a number of magisterial district justices out there who are just simply not enforcing it at all. So you may have a situation with a tenant who clearly is subject to eviction. The tenant who has been paying their rent on time, but is also kicking holes in the walls every 20 minutes, and violating every other lease provision that would allow them to be evicted. And you might file that with your local district justice, and the DJ says, oh yeah, we're not doing that. We found an unfortunate number of them across the state who are simply refusing to process evictions at all, even if they should, or they're slow walking them in various ways. So our basic advice is going to be talk to the district justice first, find out even what they're doing locally, what the process is, what the forms are, how that's going to handle, how that would be handled. And then really you just need to go to a real estate attorney who knows about landlord tenant. Because no matter what you do and how you try to evict someone, it is likely that they're going to start talking about the moratorium. It's likely that it's going to come up. You're going to have to work through that in front of the DJ. So really the only answer, unfortunately, at this point is you're going to need to talk to an attorney before you start so that you don't get yourself, neck deep in something before you realize that it's just not going to happen. All right, so that's the coronavirus topic for landlord tenant. Now we're going to get into the meaty one about escrowed funds. I'm going to take another quick sip here. So first thing you need to know is that when it comes to landlord tenant, there is no such thing as a security deposit. Now that may come as a surprise to those of you who do rentals. The reason I say that is because the law itself does not ever use the word security deposits. What the law talks about is money that is held in escrow for the payment of damages to the leasehold premises and or default in rent thereof. So you'll see on the next slide here, as we talk about this more, it's not about what you call the money that you're holding as the landlord. It's about the reason the money is being held. It's not what you call it. It's about why it's being held. So if it's being held for the payment of damages to the leasehold premises and or default in rent, you can only keep up to 2 months rent for the first year of the lease. So to make the math easy, because I don't do math, if you're renting a property for $1,000 a month, you can keep a maximum of $2,000 in an escrow account for the payment of damages. So what if I want to collect a 2-month security deposit plus the last month's rent? No, because that's 3 months. The first 2 months are what you're calling a security deposit. Why are you collecting the last month's rent 12 months in advance? Well, this was the case out of this Pennsylvania Superior Court a few years ago, where the landlord made the mistake of being honest with the court. So when he was asked this question, he said, well, we collect the last month's rent because a lot of tenants leave at the end of the lease and they don't bother paying us the last month's rent. So why am I holding the rent? Well, what he admitted to is that he was holding it against the possibility of default in rent. So if you're holding it for that purpose, it can't be more than 2 months. So you can collect a 1-month security deposit and a 1-month last month's rent. That's 1 + 1, that equals 2. But you can't collect 2 months plus the last month's rent. What about a pet deposit? Well, what are you holding it for? If you are charging, in my example, $2,000 of a security deposit plus a $500 pet deposit because you're concerned that the pet will do damages that the landlord will have to pay for, well, that is money that's being held in escrow for the payment of damages to the leasehold premises. It's what you're holding it for. What if you're renting to college students and they suck eggs and you're afraid that they're going to be doing lots of damage to the property, so you want to charge them more? No. What if you've got somebody with bad credit? No. Again, if you're charging them more because you're afraid that if you're holding more in escrow because you're afraid they're not going to pay the rent, you're holding it in default of rent. So no. If you do the math, and the math is that the amount of money you're collecting to be held in escrow is more than 2 months rent, you just can't do it. Now, there's a couple of asterisks to that, because there's always an asterisk, because what would be the fun without? If you have, and I'll use this, the example of the pet, and I'm just going to make up a scenario. You've got a landlord who says, I'm perfectly willing to rent this apartment to somebody with pets, but my experience has been every time we rent to somebody with pets, we can't quite get the place clean enough for the next tenant and they end up complaining about it. So I'll do it, but at the end of the lease, I need to tear out the carpet because that's just what I found is best. It's going to cost me $1,000 to replace the carpet. So if you were to, except for your cat, Lynn, your cat would be perfectly fine if we rented a place to you. If if the landlord says it's going to cost me $1,000 to fix the place up after the pet, one way would be to collect a pet deposit of $1,000 and use it to replace the carpet. But really what you're doing there is you're keeping the deposit against the damages to the property. Another simpler way to do it is to say, well, if you want to have a pet in this property, the rent goes up. The rent goes up from $1,000 a month to $1,100 a month. And at the end of 12 months, I will have collected my $1,000 that I need to replace the carpet. So there are other ways of charging rent that might account for this issue, because if you know that there are damages that you're protecting against, you can just collect it. It would be possible to simply charge a pet fee that's different than a pet deposit, because it is not money that is being held in escrow against possible damages. It's just more money that you need to pay me in order to move into this house. So it is possible to charge more money for a thing, but that's different than I'm charging you some money that I'm going to hold in escrow and that I'm going to assess if there's any damages at the end of the transaction. So if there are landlords, specifically pets, it seems to be where it comes up a lot. If there are landlords who are interested in doing that sort of thing, talk through how you might do it without calling it a deposit and without treating it as a deposit, but simply charging more for the privilege of bringing pets into the property. There was a question that came in advance about whether that would create any sort of a fair housing issue. I will say no, with yet another asterisk, which is to say, obviously, it would have to be applied to everyone with pets. So it couldn't be somehow done selectively or based on certain types of pets that somehow might say, if in your marketplace, people who belong to a particular ethnic background seem to have this kind of pet. So I'm trying to somehow link those two together, like there might be some sneaky way in which it leads to a problem. But simply being a pet owner is not a protected class. The other issue with that is, remember, we're not going to talk about this at all because it could just blow up the whole hour. A service or support animal is not a pet. So anything that you do that tries to penalize somebody for, say, a seeing eye dog or an emotional support animal, that's a problem. It's not a problem because of deposits in escrow. It's a problem because it's fair housing. And we are not going to cover that here today. There was a good article from, I think it was the beginning of this year. The federal government came out with some new guidelines about how to assess assistance animals. So you can go to our PAR website and you can read that if you're interested. But it is important to remember a service or support animal is not a pet. The other question on this one, is advance rent. So we have people who will say, well, the tenant said, since they have bad credit, they're willing to pay 6 months of rent in advance. In the article that we published about this on PAR Just Listed, we point out that it may be possible to prepay rent. Again, you should talk to, or the landlord should talk to an attorney, and it has to be treated as rent. So if I have a 12-month lease and I terminate the lease and move out after 6 months, if I've got prepaid rent sitting in the account, you can't hold my rent against the damages in the future for the property, because that would be a security deposit, not rent. So if it's prepaid rent and I move out early, you probably have to be willing to give me my prepaid rent back because I'm no longer renting the property. So exactly how you structure that deal is super important. Again, read the article on the website, talk to an attorney, have the landlord talk to an attorney, because it's not as simple as just filling the number in without actually providing the rationale. Your bonus topic here, it's 2 months rent for year one. It's 1 month rent beginning in year two. So if you've got $2,000, you got to get $1,000 back to the tenant somehow. Some people choose to use that as month 13 rent. Some people choose to write a check back. Some people choose to call the hotline and say, can I just write a lease that lets them waive that and let me keep the entirety of the deposit? The answer to that one is no. Just for clarity, that was a landlord making that suggestion, not the agent. That is not waivable. That's what the law says, period, end of story. Beginning in year three, if they're there for 3 years, you need to hold it in an interest-bearing account. And after year 5, you can no longer increase the escrow amount to reflect an increase in rent. So if the rent goes up by $100 a year, If I go from year 1 to year 2, the rent goes from 1,000 to 1,100. Actually, all I have to give back to the tenant is 900, because I can keep 1 month of the next year. If it goes up to 1,200 the year after that, I could ask the tenant, I can make it a requirement that the tenant give me an extra $100 towards the security deposit. If I get into year 6, however, that's capped. I can't go any higher than the year 5 rent. I cannot keep raising the security deposit. All right. Now we're going to move on to a completely different topic. We are going to move on to, well, actually, I see, does the security deposit have to be in an escrow account, or is it okay in a separate account with commingling of funds? Oh, no, it needs to be in an escrow account. It needs to be held out as a separate sorry, escrow gets me so choked up when I talk about it. It has to be in an escrow account. That's both under the Real Estate Licensing Act and the Landlord Tenant Act. All right, we're going to talk a little bit now about some seller disclosure issues. That's a high topic, and it's one of the top forms that gets discussed. So we're going to do a little who, what, where, why, when. Who has to fill it out? Seriously, read page 1. That's what it's there for. It lists the 10 exceptions to the seller disclosure law. It is not an exclusion to say I never lived there. It is not an exclusion to say it's just a rental. It is not an exclusion to say I'm flipping the property. When your client says, oh, I've got a buddy who told me I don't have to, tell them to read the front page of the form. When you, hypothetically speaking, have a brother-in-law who says, I don't know why you told me to fill out a disclosure. My lawyer said I don't have to because there's no agent involved. You should tell your brother-in-law that his attorney doesn't know what he's talking about. And perhaps the fact that I work for the Pennsylvania Association of Realtors suggests that I know the law better than that attorney. But I'm not bitter over time. People come up with all sorts of reasons why they think they don't need to fill out the form. That's why it's included right there on the front page of the form. Have them read it. Who has to fill it out? The seller has to fill it out. Does an agent have to disclose anything? Well, the law says an agent is not liable for failure to disclose anything unless they are aware of the thing that was not disclosed. So the only slightly humorous example that I use is if you are standing in the seller's basement ankle deep in water, and the seller says they've never had any water infiltration issues, you will not be able to defend yourself by saying, well, the seller filled it out. Who was I to correct them, right? If you know about it, you as the agent are potentially liable for the thing. Now, that doesn't mean you have to do any investigation, but it does mean that you need to be concerned that if your seller says, I'd really rather not put that on the form, it's not just that your seller could be liable, it's that you as the agent or your brokerage could be liable, not only from a legal perspective, but because I guarantee you 100% when that is in court, what the seller is going to say is not, I chose to do it and I beat the agent into submission. What they're going to say is, no, Bob told me it would be fine. Whether that's what happened or not, that's what they're going to say is that you advise them that that was okay. So you need to make sure that if there's anything you can see that is wrong based on the disclosure form, they need to get that fixed. When does the form need to be provided? Prior to the signing of agreement of transfer between the parties. It is not provided when the seller gets around to it. We get a lot of calls from listing agents who said, well, the seller told me I needed to get it in the MLS right away and they didn't have time to fill out the form yet. No, just no. It has to be available to be provided to the buyer prior to the signing of an agreement of transfer. In today's market, you know that buyers are going to be crawling all over each other to get offers submitted on that property, and it is reasonably likely that your seller is going to want to accept an offer within hours or days of the listing. So I didn't have time, just sell the property and I'll get around to it is bad. Why? Because they probably will not get around to it prior to them agreeing to that agreement. Do not write a contingency that says buyer and seller agree that the agreement is somehow contingent upon us eventually getting the seller disclosure form. Why? Well, first of all, you are admitting in any future disciplinary or legal action that you did it wrong, right? So for starters, the seller has to have provided the form prior to the agreement of sale being signed. This addendum basically says, dear Real Estate Commission, not only did we not have it available before the agreement was signed, but I knew about the fact that it was not provided. I knew that it should have been provided, and I took the initiative to write down words admitting that it was not provided. So there will be no defense to the question, did I somehow know that this was an issue here? Because you wrote the words that admitted you knew it should have been done already. And there is just no other way to put it than to say that the vast majority of contingencies that I've seen are just crappy. So for example, many people would write something like contingent upon receipt of seller disclosure form. So you get a seller disclosure form, and the seller disclosure form says there was a massive fire in the kitchen 2 years ago. And the buyer says, oh, I don't want the house then. To which the listing agent says, I don't care, because it didn't say contingent upon receipt and review, and the buyer has 5 days from receipt to terminate the contract and get their money back. All your agent wrote was contingent upon receipt. You got it, not my problem. So most of the ones that we have seen have just been written very poorly and have not actually been effective contingencies, even if they were in the contract and were something that you ought to be doing to begin with. So you've actually now created a second problem, because you've admitted that it wasn't done right. And since it's often the buyer agent writing these contingencies, the buyer agent may have actually written something that didn't even protect their client the tiniest bit. So they've now kind of doubled up on the thing that they could be dinged for. Now, period, full stop, new paragraph. I do live in an ivory tower here in Harrisburg. I mean, technically right now I'm in my dingy basement, but metaphysically it's an ivory tower where I can explain to you what the law says and just assume that everybody will follow the law. I realize that is not how it happens in real life. I realize that there are lots of transactions where the buyer says, I don't care about that stinking form. I want you to write the agreement on this property, and I want you to put in a contingency. The most important thing you can do as a buyer agent in that context is have written proof that you told them not to. So sending something to them that says you are entitled to get this form in advance. That's what the law says. That's what the seller was supposed to have done. I can't tell you that you're actually going to get a form because sometimes the sellers just end up not doing it, or they provide it too late. You may be causing yourself harm by moving ahead in this transaction without getting the disclosure form, because it may be very important. But hey, if you really want to do it despite my advice, that's fine, and here's how we're going to handle it. So you really want to have that written proof that says that you tried your best to talk them out of it, to avoid the scenario where they show up in court and say, Bob told me to, right? So whatever you can do. Same thing on the seller side. If you are moving forward with someone, having in writing as loudly and blatantly as possible, you need to get this done right now today so that I have it available to provide to buyers, not just saying, yeah, that's fine, whatever, get it to me. Because again, and this is not, again, this is a real call. It was the listing agent who called and said, I had a bad feeling when they didn't give it to me at the beginning, and then I had a bad feeling every time they delayed, and gosh, we're 2 days from closing and they still haven't provided a seller disclosure form. Right. So they let themselves kind of get buffaloed into a situation where it was never provided. Make sure that you are very explicit with your client. They need to do it. They need to do it now. And if they're not doing it, they're doing it very much against your advice. I can't tell you that you will be off the hook if there is ever a lawsuit or a disciplinary action, but it's the best you can do. And going back to the ivory tower, honestly, if you're dealing with a seller that makes you wonky because you're not sure they're really going to fill out the form and they're hiding something, why are you taking the listing to begin with? Go through your phone, find the competitor that you like the least in the market, and just refer that client out to them. Let them deal with the issue rather than you worrying about that issue yourself. What's the damages? If something goes south on seller disclosure, what the law says is that it's the actual damages. So if that water does come into the basement and it destroys the basement, it costs $20,000 to rehab the basement. $20,000 is the damages, plus any other legal theory. So if somebody can show fraud, that could potentially triple the damages. So it could be nothing, but it could be a ton of money depending on the situation. All right, last one here, I think, on seller disclosure is the where. Many MLSs, most, I believe Trend requires it at this point with an MLS upload. Remember that the MLS has a memory. So there may or may not be a property in my neighborhood that is for sale right now that transacted about 3 years ago that I have it on good authority has kind of a swamp in the backyard. So an agent representing a buyer today can not only find the current seller disclosure form on which the seller does not actually disclose any history of drainage issues in the backyard, but they could find the same seller disclosure form for that property from 2 or 3 years ago, and they could see, well, it looks like the seller 3 years ago disclosed that there was a drainage problem. Why didn't you? So historically, looking at the MLS, obviously sellers should be honest as best they can anyway. But if they do try to get cute, frankly, it may be extraordinarily simple to catch them simply by a buyer's agent looking through a property transaction history and finding prior seller disclosures. So that's just a little helpful hint to keep in mind. Remember as well that the seller is required to update their forms. So if there is something that they find out about that is different about the property, they need to update their disclosures. So you just need to have a policy in place as to how you do that. So if you upload a new form into the MLS, for example, but the property is already under contract, you need to make sure that your current buyer also gets a copy of it. You shouldn't assume they're going to keep checking the MLS. On the other hand, if the property is under contract and you provide it to your buyer, but the property goes south and you need to relist the property, you need to make sure that the listing agent remembers to re-upload it into the MLS. So just making sure that you've got policies and procedures to handle that. With that, what I'm going to do is I'm going to skip right ahead because we hit about the hour. And I don't want to keep people here longer. I filled this up with a whole bunch of extra topics, just depending on the time. But I do want to stop here and see if there are any questions that anybody has that I can answer before we are done here. Mitzi, hello, Quinn. Right back at you.
Did you see Todd McCarty's question? When an executor trio completes a disclosure, should they initial pages of SPD or just sign?
Yeah, so that's actually an interesting question that just came into the hotline a couple of days ago. Not sure if it's the same transaction. The answer is that the only thing the law requires is that a form be completed. The sample form from the Real Estate Commission has the signature for the executor. So all that would be legally required is the executor to say, this is why it's not filled out, and they sign at the end. That said, what we've been telling people who ask about initials, it's not legally required, but if the agent says, for example, it would make me more comfortable to know that the executor actually flipped through all 10 pages and then purposefully left them blank, as opposed to the listing agent just slid the signature line, the signature page across the table and they signed it. Some listing agents will ask them to initial every line just sort of as an acknowledgement that they saw it. I'm sorry, every page. But it's not legally required. It does not invalidate the document, whether it's an executor or a seller. That's there as a convenience. It is not there as a mandatory thing that has to happen to make it valid.
Can you look at the questions that are being listed on the chat?
Is that Andrew?
Yeah, there are other questions on the chat.
Yeah. Okay. So I see. So are you talking about the one about the seller disclosure? Where do you as an agent disclose the thing if it doesn't disclose? That is an excellent question. What's next? That if we were in person, that would be hopefully where people would have chuckled and I would have heard you chuckle. So I'm just going to assume that you were laughing on mute. There is nothing, there is no document that is the agent's disclosure of things that their seller is lying about. And I phrase it that way because that is essentially what is happening in that transaction. So if you get to the point where you as an agent are saying, this is really making me uncomfortable because there's this thing I'm really concerned about that needs to be on the form, there's a couple things that you have to do. One is, and this may sound obvious, but talk about it with your seller. So say, I see, we'll use my example again. I see that you put that you've never had any water in your basement. I know that not to be the fact because I saw the water in your basement. We need to fix that. If the seller says, I don't want to fix that, you got two paths. One is figure out how you can disclose it to potential buyers. The other, seriously, is to cut them loose, because basically their failure to disclose something that you've identified really means that they are lying and that they are making a misrepresentation. So what we generally advise at that point is your strongest play is to really consider getting out of the relationship to begin with and not have to even get there. If you get to the point of feeling compelled to disclose a thing, there is no form, as I said. You really need to talk to the broker, figure out how they would want you to do that. I have been told, I've talked to a couple people who have done something like this, where they might send a letter to the buyers, or they might include something as part of a counter offer that says, in addition to the form, before you sign off on our counter, here's something else you might want to know about. But honestly, any of those situations really put the agent in a really bad spot. So the best advice is going to be try to get them to do it in advance. And if they don't, really consider just moving on. I do see a note from Lynn: isn't the executor required to disclose what they know? This is one of those weird gray area things. The seller disclosure law says that an executor is not required to fill out the form. General common law says that if you know about a thing regarding the property that is a bad thing, that would be a material defect, you're obligated to let people know about it. So generally speaking, yes, the executor, if they're aware of any substantial material defects, would generally be required to disclose what they're aware of. And that would be the reason why a listing agent might ask them to look through the whole form. To say, look, you don't have to fill out the whole form. We don't need you to go through and answer every single question, but I'd like you to read through this and look at the questions, look at the headers, and see if anything comes to mind. So by way of example, I am pretty aware of the fact that my parents have done copious amounts of unpermitted work on their property over the years. I don't know when exactly they would have needed a permit and when exactly they didn't need a permit, but I do know, for example, that one year I was going into the attic and my father said, oh, hey, when you get that thing over from the right, be careful, because remember we have that extension cord from our front lights that snakes through the siding that we plug in the attic. Pretty certain that's not up to code. So if they were to pass away and I were to sell their house, I would probably disclose, I'm aware of the fact that there's unpermitted work. I don't know exactly what it is. You should call the township. But it doesn't mean that I have to go through and answer every single specific question on the form, yes or no, just that I have to disclose the things generally that I'm aware of. Question from Todd: property gets listed and there's a new leak from the roof. Should the executor then update the disclosure? Yeah, so generally speaking, and I realize how simplistic this sounds sometimes, more information and more disclosure is better than less. So regardless of whether it's an executor or an owner at that point, if you know that the condition of the property has changed, then that is something that needs to be disclosed to potential buyers. Even more importantly, once the property is under agreement, it definitely becomes an issue, because now you're under the maintenance and risk of loss paragraph. So it has nothing to do at all with the disclosure rules. Now there's a problem with the property and we need to go through the maintenance and risk of loss paragraph and figure out how to handle it. All right. Next question: seller refuses to sign a release. Yeah, so I'm gonna look back at some combination of Lisa and Pam. I've got a couple of slides actually talking about this scenario. Do you want me to give the 30-second answer, or do you want me to go back and give the 4-minute answer with the slide?
We have the time. I mean, if you think that the 4-minute answer is what is needed, whatever you think is necessary to answer.
Okay. I mean, I get tired of hearing myself talk, after 60 or 90 minutes sometimes. So I just want to make sure that we're all on the same page. So let me go back. Let me go back to this slide here. So this is what I call the chocolate cake rule. Not that this ever happened to me in my childhood, but mom puts a piece of chocolate cake down between the two brothers and says, you've got 30 seconds to figure out how to divide this cake, and if you don't figure it out, I'm eating the cake. So the law in 2009 was changed to say, instead of the broker can't distribute the funds if there's a dispute, was changed to say the broker can't distribute the funds if there's a dispute, unless the parties have pre-agreed what happens to that money in the event that there's a dispute they can't fix. The main point here is it gets the money out of the broker's account. So if the buyer and the seller still want to fight over it, they can, but it's not going to keep it in the broker's account. And literally, we've had people who have called who have had money in their account for 40 years. So it doesn't tell anybody who's entitled to the money from a legal standpoint, but it gets the broker out of it. Here's how that provision works. Date X is what I'm calling the number of days that is in that paragraph. So it says if there's a dispute that is not resolved within blank days, the blank is date X. So I'm going to use 30 in this instance, just because it's a number that seems to be coming up a lot. So it says if a dispute is not settled within 30 days, blah, blah, blah. So what happens? The default is if this dispute is not taken care of and there's no litigation or mediation filed, the buyer can ask for their money back and the buyer gets their money back. So the first thing to know is that the buyer can request the return of their deposit at any time. Filling out a release that says buyer to get the $10,000 is probably not sufficient. It probably needs to be something more specifically that says, in recognition of a dispute that has not been resolved, I want my $10,000 back now, but you can do it at any time. So in theory, on day 5, the buyer could send a letter that says, in the event this is not settled by day 31, consider this my request for the money to be released to me starting on day 31. Most buyer agents, I believe, generally advise against that, if only because it's kind of tips the seller off to the timeline. And sometimes they would rather have the seller dither for that period of time and not file anything. But you can do it whenever you want, day 5, day 29, day 31, day 70 for that matter. But nothing happens until after date X in terms of actually distributing the money. Once that request comes in, anytime after X+1, the broker is required to return the funds to the buyer within 30 days of the request if there has been no litigation or mediation filed. What does that mean? Literally just yesterday, I had a call from somebody who said, that like every 20 minutes, the seller sends me another letter that says, you better release the money to me or I'm going to sue you. That is not filing litigation. That is threatening litigation. So it has to be actually filed, and you have to get actual written, verifiable written notice that it has been filed. So like a copy of the filing, copy of the docket sheet, something like that. If it's mediation, generally speaking, if it's filed in advance, the mediation notice is because the association sends the other party the copy of the request. Sometimes if it's a quick deadline, you might actually just sort of send it to the association and send a copy to the other party. But it has to be filed. This is the important part. The action has to be filed before the request is made for the broker to be required to keep that money in escrow. So again, using my example of 30 days, if litigation is filed, I'm going to actually back up. If mediation is filed, because it should be mediation, if mediation filed on day 25, you're going to get to day 30, there's no question. There has been mediation filed. The other party is aware of it. The broker has to hold the money till the mediation is taken care of. If the request from the buyer comes in on day 31 and the listing broker says, oh crap, I forgot to tell you that you needed to file for mediation. I'm going to call you up now and get you to file real quick, and I'll just hold the money until then. And then I'll say, ooh, I guess I have to keep it in escrow. No, that is not what the contract says. You can read that line. It says that the notice has to have been received before the request from the buyer. So what I can tell you is if you as the listing broker try to do that and you keep the money anyway, even though that's not what the agreement of sale says, I'm not aware that this has been the subject of a complaint, but I can tell you that that probably, if it was investigated by the Real Estate Commission, could be considered to be a violation of the escrow rules, because the parties have agreed in the agreement of sale, if there's no notice before the request, you give the buyer the money. You chose not to give the buyer the money. That is not what the parties agreed to. You are violating the terms of the escrow funds that you are holding. So don't get cute, right? Your job is to help your seller understand what they can do to retain the money. In that circumstance, make sure you tell them before the deadline what to do, not after the deadline. And remember, after the deadline, if the money is returned to the buyer, you can still sue. Everybody still has all their actions. They can still mediate. They can still litigate. All it means is that the broker is out of that situation. All right, that might have been like 6 minutes, but there you go. All right. So I don't see any additional questions, so I think I will turn it back over to you.
Thank you so much, Hank. Lisa just put something into the chat that we have a couple of poll questions that we're submitting to everyone on this event. We're looking for some help in crafting our academic calendar for